Good afternoon, everyone. We are here now for day 7 of the Robert Tellis murder trial, and it looks like Mr. Tellis is going to be finishing his testimony today. It started yesterday. It was quite the show. Not much different than what we all expected, that it was going to be a demonstration of why people should not take the stand in their own defense. But again, this is an attorney, Robert Tellis. He knows the rules. He's been to court before as an attorney, and he is breaking the rules. The court has admonished him for breaking the rules, and I would expect that at some point, either yesterday after we stopped our live or this morning before court begins, the court is dealing with some of the objections that were raised by the prosecution, dealing with some of Robert Tellis's attempts to admit evidence that are outside of the general rules of evidence in the state of Nevada and in pretty much every state in the union. But we shall see. I see that Miss Carol is here. Good to see you, Miss Carol. Jeff, Bernard, good to see both of you. Natalie, good to see you all here. I did try yesterday evening to answer any questions that we got. I know there was at least one question, and I do appreciate the questions. Much like the jury staying involved, I'm glad to see that everybody who's here has remained involved and actually been paying attention and is asking me questions about what's going on here in the case. We do have the seal of the state of Nevada showing in the courtroom, so they are likely to begin here pretty soon. So I don't want to get too far afield before they get started because I want to.
We can put the witness back on the stand and you can bring the panel in.
You want them up there first? Or?
Uh-huh.
This is testimony by narrative, the continuation of the testimony by narrative. Afterward, the prosecution will get the opportunity to cross-examine this witness and ask actual questions that he did not necessarily prepare for in his narrative, which he apparently has been working on for the past 2 years while he's been sitting in jail. We got another storm here today, so please forgive any technical difficulties that may arise from time to time.
All right, you're entering jury, please.
Just to remind everybody who's on the stand, let's go ahead and
Does the state
show that
agree to
ticker.
the presence of the jury panel? Yes, Your Honor. And the defense?
Yes, Your Honor. Thank you, Lauren. Please be
Would you
seated.
please remain standing, raise your right hand so the clerk can administer the oath?
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
Thank you.
Please state and spell your first and last name for the record.
Robert Tejas. First name is Robert, Robert. Last name is Tejas, Telles.
Okay, you may continue.
Thank you, Your Honor. And again, with respect to Compass Realty's motives, I wanted to show you a probate court video. I'd like to see if we could share that.
This is going to be D3, and it's not been admitted yet.
You objected, Your Honor, on this matter. I guess we are.
So we got our first objection. While the court is dealing with that, let me point everybody's attention to Nevada rules of professional conduct for attorneys. Rule number 3.3, this is candor toward the tribunal. It says that a lawyer shall not knowingly offer evidence that the lawyer knows to be false. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. However, it goes on to say a lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that the lawyer reasonably believes is false. So in a civil case, the lawyer can refuse to offer testimony that the lawyer believes to be false. But in a criminal case, you got to let that criminal defendant say whatever he's going to say in his own defense. So that, again, could be the reason why we are seeing testimony by narrative here, because the defense attorney believes that this evidence is false. This is a possibility. Believes that some of this evidence is going to be false, some of what Mr. Tejas says is going to be false, and does not want to implicate himself into the giving of false testimony. So he's allowing Mr. Tejas to give that false testimony, possibly the possibly false testimony by narrative format. And we did read a similar situation here in Florida. So this is, again, likely because the attorney, Robert Draskovich, is trying to follow the rules of professional conduct.
Go back with the jury panel. However, I'm not going to allow you to publish.
So he can't publish this exhibit.
Go back, if you could please review that video. I would like to ask if, getting back to where we were yesterday, if I could ask that we please share, well, first of all, I'd like to share a picture of the killer's pants. I believe it is a zoomed in version of one of the videos that was provided by the state.
We have it.
Yeah, we have the photo, we have the thumb drives, better representation.
I have it on my computer as well. It's clearer if we do it this way.
Okay,
It's been
and it's
previously
exhibit,
submitted. Yes.
Yes.
it states exhibit, just for the record.
I want to say 370, maybe it's,
What are they trying to show?
It's
The
the-
It's
state
the PIO,
exhibit
it's the
that's been
lowest.
admitted, I just,
It's
before
the
you
lowest.
publish.
yes.
What was the number of flash drive?
It's
Oh,
a-
the flash drive?
Correct, we addressed it yesterday.
Okay,
It's also the flash drive that they gave us money as well.
that's going to be court's indulgence, state's exhibit 338.
There's 338.
338, and you may publish.
Yes.
Chris. You guys are in here every day, so
What are we trying to do?
just that picture. I
I'm
don't
just zooming in.
even know where that's coming from. So.
Well, my guess would be you have this item, it's like, so, let's just close it. Don't know why that's.
The young lady in the blue dress who's been sitting behind the defense table this entire trial is actually a reporter.
If I may, I'd like to publish Exhibit A. I'm gonna hit it in there.
We are just beginning, and this is already a logistical nightmare, apparently. It doesn't look like he coordinated at all with his attorneys with respect to the presentation of any exhibits or whatever evidence he has in this case. We're comparing now the pants that they took from him to the photo.
I'd like to show the two, my jeans versus the killer's pants. I personally don't believe that they look the same.
Objection, his opinion is irrelevant.
Right, sustained.
Okay. And I'd like to also note that none of my other pants, jeans, or anything else were taken from my home on the day of the search. As a result of my jeans being taken from me that day, I was put into that paper suit. And you've seen the photo of the paper suit. And the room was cold. I asked, well, when I attempted to have the temperature adjusted, there was no help there. So I spent the day freezing in that paper suit.
All right. So I know I just read the rule and I commented that perhaps the attorney doesn't want to implicate himself in lies. It could also be that the attorney just doesn't want to implicate himself into this defense strategy of I was cold and they took my pants. So that it could be that he's telling the truth in all of this, and the defense attorney is just like, this is a bad idea. This is not going to play well in front of the jury. I don't want any parts of it. That could very well be. I apologize. It looks like we are experiencing some technical issues, perhaps due to the weather here in South Florida. Usually sunny South Florida, but not today.
Various things that were done to, I believe, break me.
Here's the pity party. Let's
I
listen.
had conveyed concern all along about my family. And as time went on during this detention, interrogation, whatever, I learned of various things that I believe would tend to, and did for me, break someone's spirit. I was informed that all of my vehicles were being taken away. And this was early in this interrogation. This was before they supposedly found a shoe, that they were taking all my vehicles away, which made no sense to me. When I wanted to reach out to talk to my family, to try to put them at ease, I was denied the ability to make any phone calls. When I wanted to speak to an attorney, I was denied the ability to talk to an attorney. It was my understanding that my rights were being suspended because I was not arrested, I was just being detained. Later again, detectives took advantage, I believe, of my feelings for my family by referring to them over and over. And, you know, it was a lot. Then all that finished. They were finished with the search, and they took me back home. And the media was outside my house, and somebody followed me all the way to my garage door with a microphone in hand. I don't know if I'd say chasing me per se, but she was walking pretty briskly all the way up to my house. And while that was, I'm sure, her right, I wasn't. It didn't help the situation. You know, to know that the media had been tipped off and they were swarming around the house. Then I walked into the house, and what I saw hit me even harder. I'd like to share the photos of my house after Metro finished their search. I think it's A2 to maybe S2.
That's going to be A2 through I2. Yes, A2 through I2.
The police department certainly does not clean up after itself after they execute a search warrant. So I anticipate that we're going to see photos of them having left his house a mess, but that's what they do. They do it every time they execute a search warrant. This is no different. He's basically saying, I wasn't treated differently than anybody else. The police came, they created a state of disarray in my home, and they left it that way.
Yes, Your Honor.
Okay, they're admitted into evidence,
And Mr. Dreskovich, oh, I'm sorry.
do you want to publish?
I would, if you would mind, could you take maybe 10 seconds of photo and flip them for me?
Okay.
Thank you, sir.
Do you want to see the photos? Is that what you're asking?
Well, I guess maybe, but when we publish them, if you could publish them for about 10 seconds apiece. And then what I'm concerned about publishing are the photos of the inside of my home
They are.
and what, okay.
Yes.
So, thank you, sir.
This is A2.
So this is what I walked into in my house starting.
This is A2, A1.
So the reason we don't usually see these in criminal cases, like what the house looks like after the search,
Similar looking photo?
Yes.
Okay.
Are you done with this photo?
Yes, sir.
All right.
is because it's of no evidentiary value.
This is,
It doesn't help the jury decide the case one way or the other.
And coincidentally, I was led to believe that they were not going to make a mess of my house.
this is C2.
I will say this, the bedroom, remember the officer, the SWAT team member testified that the bedroom was in such a state of disarray that the robot could not get to the bathroom. And this is the first time that it's piecing together in my mind. The police left it in a state of disarray, which is why the robot couldn't get to the bathroom. It's not that Mr. Tejas or his family just kept an unkempt home. The police left it that way.
F2.
And while, again, that's of no evidentiary value, it still, provides some context, I guess.
This is G2.
the defendant is apparently crying now.
This is H2? This is I2?
No, we don't know what it looked like before, Miss Carroll. But when we were looking at a picture of the garage, when the officers
And this is
conducted the search of the garage, and there was a picture of the garage that they showed where the garage was neat,
So I found my wife sitting on the floor in our bedroom. in the
and
middle
that
of
must
this
have been taken before the search.
So this for me was, the thing that just broke me. I'm sorry. I knew I didn't do this thing, and yet the police claim to have this evidence. They did what they did to me, and I have a $1 million life insurance policy. I didn't want my family to have to go through more torture. And so I don't know what I was thinking, but I thought, you know what, if I can avoid the pain that they're going to suffer during this whole circus, and put some money into their hands to make up for me not being there, then maybe this is the thing to do. But it was, for me, never, I'm not guilty. I didn't kill Mr. Gurman.
Every life insurance policy I know of has a suicide clause that says, if you take your own life, we don't pay out.
But as you can see, I attempted suicide. And SWAT came in and pulled me out and put me into that ambulance. Detective Jappy came into the ambulance, and when he came to the ambulance, he came in to extract a confession from me. It was conveyed that if I would just plead guilty, that
Objection, hearsay.
Sustained.
and in response, I said that I'm innocent, but I don't want my family to go through this, this thing that's going to happen. I guess what I said exactly was, I know that I would prove I'm innocent at trial, but I don't want my family to go through the pain. And I wish that I had the audio to prove that to you, but apparently it doesn't exist. I'm not certain how we ended up leading off with Mr. Gurman's, I guess the response to Mr. Gurman's request for the messages between me and Roberta, the emails and the Microsoft Teams. The production of those items that were given to, or that they were going to give to Mr. Gurman, it's a lot. I think it's probably hundreds of pages. So I think we were trying to see whether or not we could produce them electronically so that you could review those messages for yourself and see whether or not they're a motive for murder.
Your approach, please.
All right, so he's talking about those communications between himself and Roberta Lee Kennett that Mr. Gehrman had put in the FOIA request for. And there was some indication by the prosecution that it was the pending release of those communications that kind of prompted Tez to act when he did. Notably, the prosecution didn't put into evidence a single email or communication from this, swath of communications that would have shown some sort of a illicit relationship or or anything nefarious, anything that could be criminal or underhanded or fraudulent or anything else. So he's basically saying, look,
Understanding based on representations, that exhibit will be created and it will be marked and admitted after it's created.
I want the jury to see all that, and the judge is allowing that to happen. We're not going to see them, though.
Thank you. And well, and it's my understanding they already produced that item. I don't know if we can make sure that what they're producing is,
It will be provided to you shortly.
Absolutely, you'll be able
Okay.
to review it.
I would like to now share a photo of my Yukon that was taken at the police impound in their garage. It's O2.
We can move for its submission, or I believe it's being admitted by stipulation.
It's admitted,
And if we may publish it.
absolutely.
You're absolutely right, Jeff. So far, he's not really debunking any of the
This
evidence.
is a photo of my Yukon that, again, was taken by the police at the garage. If you will note, my Yukon doesn't have worn paint around the windshield like the killer's does. I'd like to note that I am in jail. I don't have access to Photoshop. To Photoshop this photo so that to remove any alleged paint, worn paint. I don't also have Photoshop to modify the picture that Mr. Mogg took that shows allegedly that there was worn paint on my car. I'll also
View that would be required to show the top of the windshield and the very small portion that Mr. Moss was referring to that was discolored. And I don't know that the jury has any photographic evidence of this discoloration that Mr. Moss testified to. Again, I apologize for the delays due to the inclement weather. I'm going to have to stop pausing it, apparently. So thus far, he's dealt with or attempted to deal with his wound on his hand, the emails, and the discoloration of the Yukon. Those are the only pieces of evidence that it seems he has attempted to deal with. The rest of this, as far as today is concerned, the rest of this is just, hey, the police department treated me poorly. Give me a sec. Let me try to reload this this stream. Get back to where we were. And again, I do apologize for the difficulties.
And so that's what I've got for that photo. Thank you very much. The cameras that are on the corner of my house, I did install those on September 5th after my wife and I heard what we thought was a gunshot in the neighborhood. If, you know, and I think that it'd be pretty easy to, you know, well, I know that I said that to Detective Gaddis in my interview, and also it was previously discussed that those cameras were not there during the surveillance on the 1st. So Mr. Mogg would not have found videos for the 2nd, for the 3rd, for the 4th. Personally, I believe that when there's no videos for all those days, I'm not sure how it could be so.
Sustained. And you
No
can
problem.
testify regarding your observations.
Of course, Your Honor. Like that, sir? Is that okay? Okay, thank you. And so, I believe both, well, I mean, I can't tell you what other people testified to, but I will say that that day, on September 2nd, at 8:50 a.m., I did make a text message from my house. And I did not leave my house. And I'm just going to hit this one point really quickly. Through 9:10 a.m. at the very earliest. Okay. As I testify later, it was much later that I left my home, but again, that's, I believe, an important point. So 8:50 sent a text message, 9:10 I was still home. Now, I would like to share, if I may, R2.
I missed that. So he says he's home at 9:10. What about after that?
That I made that had any reference to Mr. Gurman.
This has not yet been admitted.
And it's marked as
R2.
The state had produced a Twitter file that was not in, you know, your typical web browser format, and so when we went to review this, this is how those tweets came up.
any objection?
No objection.
It's admitted, and you may publish.
Maybe let's. So you'll notice that you heard about that tweet where I talked about where I joked about hearing rustling in the trash, you know, just a dig at Mr. Gurman, and that was the one that's listed on I believe that's 6:18 at about 7 at almost 8 in the morning. You don't see the other tweets because again, for whatever reason they didn't. When they produced this document, they didn't produce replies embedded in it. So, but that's the same one. And you see that my last tweet regarding Mr. Gurman is on 6/19. And there I say, at @JGurmanRJ, @ReviewJournal. Actually, it wasn't lashing out so much as making sure that you finish the story about the website and maybe poking a little fun. A winky face emoji. You know, I had created, and you'll see that, as has already been admitted, I created this portion of my campaign website that talked about the stuff that, you know, that was different things that I disputed. And so I wanted to draw attention to that, so that's why I goaded Mr. Gurman into that a little bit. About the same time, it was actually June 16th, I had sent a text message to a friend who had reached out to me about, because he was, you know, he just wanted to check in on me. And on the 16th, I conveyed to him that it's all good. I'm not actually mad at it. At this point, I was over it. You know, I'm happy to move on. You know, and I, you know, I said, although, Gurman says he's going to do a third article, one about the website. I don't give a damn. LOL. I don't know if that's something that we can, thank you, sir, that we can admit, this text message.
Are you asking?
If we may, or if you could present it for admission.
What is this?
This is an exhibit that he wishes
To offer.
to offer. We can make this as a proposed exhibit.
Yes. This is going to be J3.
Thank you. Please, absolutely.
Thank you.
No objection.
There being no objection, it's admitted and
Thank
may
you.
publish.
So you can see the content of there again, 3 days before I sent that last tweet. So again, there were never any messages where I would threaten Mr. Gurman. I'm certain that if there were, they would have been produced. Thank you, sir. I, the way that I handle things is I figure out ways to do things legally. And I'll discuss that in a little bit as to what I was planning. Your Honor, may I just stand up for one moment to show the jury why I didn't wear name brand shoes at the office? Just for a moment, and
You just want to stand up?
right where I'm at.
Yes.
Okay. So, I don't know if you notice the height difference. I wear lifts in my shoes. But I'm about 6'5.5", and I call it a vanity thing, right? I just wanted to feel a little taller. And so, if I may just demonstrate why this is important. So, these shoes that have built-in lifts, they're designed in a certain way where they don't slip off a person's foot when you're wearing them, right? You can see how this is so elongated because there's a lift in here, right? So you can't put, it's not, from when I've tried, I could not put a lift in a name brand shoe because that shoe would slip right off. There's not enough of the back of this, once that lift's in there, in order to grab a hold of your foot. So essentially, I'd be kicking my shoes off every time I walk. So, I never wore, again, any type of name brand shoe at the office, and I think that's something that'll likely be discussed at closing, and how that's relevant. Which, of course, brings me to the shoes in the house. I did not cut up a shoe and hide it under my couch. I did not cut up a hat and put it in an open door of my toolbox. I did not kill Mr. Gurman, so I did not take a bag with my children's basketball and football out of the bin and use it during the commission of a murder. So, again, I didn't kill Mr. Gurman. I was, well, I guess, my next statement would have been argument, so let me skip that. And I think my attorney has already kind of discussed with you the deletion of this body cam video. I guess next I just want to share, well, I'm going to try to share some thoughts with you about the killer. It was strange to me that the killer,
Objection, proper opinion.
I didn't get to hear, so, what did you,
I'll-
what's the topic?
well, I wanted to talk about my observations about the killer.
Okay, you can testify about any facts and observations that you've made.
Observations that I made about the evidence that I've reviewed, Your Honor?
Sure, go ahead.
Okay. It was strange to me that the killer walked around the neighborhood.
Okay, again, that,
It's
it,
hard.
facts and observations that you have made.
Right, and I was clarifying earlier that if I reviewed the evidence as provided the state, but that's okay, I'll
Thank you.
I'll move on. So I did not, oh, make sure I get my order right here. So you saw a document with certain searches that said Jeff Gurman, Las Vegas, Jeff Gurman, Las Vegas, Rob for NV, those type of things. I'd like, and my apologies, I should have actually sought this out earlier. I don't know if we can, it's a state's exhibit, if we can dig that up.
What is it?
It was a list of searches for Mr. Gurman that was provided by the state, a lump of Cellbrite items.
Is that an extraction report? Yeah, it would be extraction. Thanks. If you can approach and help me pick which one you want.
So it looks like he's still talking to the jury, even though we're muted because the attorneys are talking to the judge. So I'm a little confused as to what's going on right now. He's trying to go back to the state's exhibits where they pulled up his search history where he was conducting his own investigation into the decedent. So he's dealt with the majority of the evidence at this point. It wasn't his. He doesn't know how it got in his house with respect to the hat and the gloves. And he
Search
certainly
results
didn't
actually
use
get
that duffel
pushed,
bag.
or like pages get pushed up, is when
Commit a crime.
people review, or when people do a search and they visit a particular page based on the fact that they did these search terms, that would actually increase the ranking of the page. So I'll explain. So for example, again, if you Google Rob Tejas or Jeffrey Gurman, Las Vegas, Rob for NV, then you go to my page and you find the page and you click it, then Google's going to say, okay, we're going to push this up, right? When people search, we're going to get it further up the chain. And so when I was doing these searches, you'll see, sir, is it?
I may approach
You may.
Yes.
Exhibit.
State's Exhibit 356.
Thank you, sir.
Is he admitting to doing the
Sir,
searches?
May I ask you to kind of
I'm-
go through this
I'm confused.
slowly on the Elmo, if you don't mind? If you don't mind, please.
You may publish.
If I was trying to search for Mr. Gurman's personal information, I don't believe that I would repeatedly Google him over and over again. If you might focus, I don't know if you all can, if you might zoom in just a little bit more if you don't mind, sir. So you see that it starts off Jeff Gurman, Las Vegas, 4 times. Then I added Jeff Gurman, Las Vegas Public Administrator. And if you could flip that page, please, sir. And then from there, if you could go down just a little bit, if you don't mind, just so I can read the very top. Okay, Jeff Gurman, Las Vegas Public Administrator again. I did that a few times. And then if you could, and again, so if I was trying to find his address, I wouldn't be putting Public Administrator in the same search, right? If you could please flip that as well. So here I was trying to build a pattern. So next, I searched Jeff German, Las Vegas Rub for NV, which is my campaign website. Right, so later, as I continued to research, I found out that the only thing it was going to do is bump the search result up on my own browser. But thank you, sir. So I ended up finding that there were paid services where you give them a credit card number and a certain amount of money to spend, and they have either one of two ways of doing it. They either have people in some other part of the country or the world manually typing in these search terms, from different spots to, and I guess it's, I don't know if you'd call it cheating to have somebody artificially pushing your website up, but I felt like, with what Rita Reed had done, that, if she was going to lie, that it was fair game for me to try to push my website up so that people could read the truth, right? So that was the purpose of those searches. But I never searched for Mr. German's address. And yeah, I would think that if I had, you would see a landing page of some sort that actually showed I searched for his address. So when I saw the supposed searches where I supposedly looked.
All right. So if you're trying to find somebody's address, you can't put their address into the search bar because you don't know what their address is. So you kind of just got to put the information you know about them, like, I don't know, the city they live in, and hope that it comes up with a result that'll give you their address. But according to Mr. Tejas, he's trying to bump up his own campaign websites, Google search term results by searching for things like Jeff German, Nevada. Somehow that's going to boost up the results that are obtained when other people are searching for things, and it's going to push his campaign website up. But he said, I never searched for Mr. German's address. But we all saw the Google Maps results of all of the images of Mr. German's house. And to Ms. Carroll's point, if you want to boost your own campaign website, wouldn't you just Google yourself? Not somebody else who's tangentially related to your website? This makes absolutely no sense to me.
His address when you're putting it into, at least from what they showed.
My apologies. I was muted there. He's saying now that he has this Google Maps thing. The Google Maps thing, in order to get a Google Maps image, he would have had to have the address, but he never searched for the address, which means he couldn't have done the Google Maps search. So if I didn't have the address, then I couldn't have done the Google Maps thing. But we all know that if you put in somebody's name and their city into Google and search for them, if their address is listed anywhere on the internet, Google is going to turn back a search result that has that address on there. And then you can just type it into Google Maps. This entire testimony is so convoluted, and I'm having trouble following the train of thought that even led him to believe that this testimony was going to be helpful to him. But apparently, he spent all this time in jail coming up with this. Let's get back to it.
And you know, I guess it's, you know, I don't know if you'd call it cheating to have somebody artificially pushing your website up, but I felt like, you know, with what Rita Reed had done, that, you know, if she was gonna lie, that it was fair game for me to try to push my website up so that people could read the truth, right? So that was the purpose of those searches. But I never searched for Mr. Gurman's address. And yeah, I would think that if I had, you would see a landing page of some sort that actually showed I searched for his address. So when I saw the supposed searches where I supposedly looked for his car, you got to have a man's address when you're putting it into, at least from what they showed, that supposedly they found the car by way of his address. I didn't know his address. So, and again, and I think if you would have seen some landing page showing that I knew it, I didn't know his address. Never been to his house. Didn't do a Google Maps search of him. And when it came to these photos that are supposedly surveillance, I don't know why anyone would do that. Sit there and take a 100 photos of different cars. I don't even understand what the purpose of that is. It's my understanding that surveillance means you go tail a person, not sit there and snap off a bunch of pictures. And then there were these other items that the state had introduced, you know, photos of articles, like screenshots of articles, screenshots of the, was it Facebook messages, like a discussion that I had with John Cahill. And those are items that I was actually collecting for a lawsuit. And I don't, did you all bring a copy of that lawsuit, the lawsuit draft? Rick, would it, may I? So I had been writing a draft of a lawsuit, and as I said earlier, this is the way that I wanted to handle this issue. If we may take a look at it so I can tell you.
Thank you.
He didn't have his address, so he couldn't have gotten his car information. This is muted. Here we go.
I couldn't sue my employees because that would just look bad. But I felt that after I lost the election, you know, they were fair game. Because my original thought was that, you know, if I won, or if I tried to sue them in advance of the election, that people would say, you know, he's just trying to shut up people, right? And I got advice to that extent. And so I took it. I said, okay, well, I'm from an attorney. I'm like, all right, well, I won't sue them now. And my hope is that I was going to win. And I think I came pretty close, but it is what it is. So once I lost, I said, you know what? Fair game. I'm going to sue them. May I? Oh, I am so sorry, sir. Okay. Okay, and so again, this is a draft of a lawsuit. It's an unfinished lawsuit that I had started drafting, and it was going to be on behalf of myself as my own attorney, as part of the law firm that I had, Accolade Law. And I would like to ask that this be admitted.
Any objection? Is it admitted?
So you can review that and see that, again, this is the reason that I had actually captured some of those pictures. Oh, sorry, sir. Okay.
He captured the pictures of those cars driving down the street to aid him in his lawsuit against his employees.
And I guess, you know, I had done my own research on cases, and I had found that there were actually cases where even DNA evidence had been planted. There was a case where apparently it was an officer-involved shooting, and the police were pretty sure they had their people.
Objection, relevance?
Yeah, the objection is sustained.
Okay, well, it goes to my theory, but I guess we'll have to save that for later.
What happened in another case doesn't matter. The only thing that matters is the facts and circumstances surrounding this
Okay.
case.
September 2nd of 2022. As I mentioned earlier, I sent a text message, hung around home, had no watching TV or working. Somewhere probably around 10-ish, I went for a walk. Came back home, and then got ready and went off to the gym. And if I could republish T2.
This has already been admitted?
Civic witness just prior to.
Absolution.
Thank you, sir. If you could please turn to the appropriate page. As I said before, I'm techie, right? You see that my actual login, you know, after you consider everything I do, you know, to get ready to go to the gym, when they were ready to scan my phone, it was at 12:09. And I say it was my phone because, again, because I'm a techie person, the tag that was on my keychain, I abandoned it long ago. You know, so that was from my phone. May I next republish, I believe it's States Exhibit 374 regarding text messages I received that day?
He just testified that he logged into Planet Fitness from his home. From his phone. His phone was at home the entire time.
If you don't mind,
How did he log in to Planet Fitness from his phone?
Will be published?
It's about 20 pages.
if you don't mind, we can just go through it briefly. My apologies. If you could go ahead and turn to the next page, please.
Number on the side.
It's 374.
Thank you so much.
So if you could turn the page, please. Okay, if you could turn the page, please. You turn the page, please. If you could again turn the page, please. Now you see again that conversation I had with my daughter. Had my phone, responded, no problem. At 9 o'clock, still had my phone when I got an email from Jimmy John's. You could turn the page, please. Still had my phone when I got this message from, if you bring it down a little bit, or the other direction, please, from Cora. And when I got this text message from this spam, talking about how they wanted to sell my home, I didn't respond to that. If you could please, when I got the message from Macy's, I didn't respond to that. And again, still had my phone. When I got this, if you could go to the next page, please. This is, so we had recently changed our, at the office, the way that, or our vendor for the answering service. And with that, I asked that they create a system or implement a system where we're automatically texted for these things. Again, no response required. This was something that was assigned to Rita. It was just provided to me for my records. So nothing to respond to. Again, another email, no response needed, just junk mail. Sir, please. Again, another message from the answering service. Then at 10:36, I got a message from my wife with a picture of my daughter. And then if you can go up, my wife called about 10:43. I'd been out for a walk. I was just about to come in anyway, so I didn't respond. You'll notice that she did not call me again. She did not text me again. That's because I said, honey, I'm home. So can we go to the next page? Again, another junk mail. Then a phone call from Reputation Defender, junk. I don't feel the need to pick up the phone from everybody who's calling. And then another email, again, automated email, if you could change the page, please. Again, calendar invitation, junk mail, calendar invitation. And you'll notice by this time it's already 12:53 when we're at number 32. So I already have myself at the gym, right? So it's not like, I've got to answer any of these things, right? And then I was done at the gym. I want to say I typically take about an hour there. And so it was, I don't know why I would have missed this call if I was in the shower or whatever. This would have been from the vendor for my daughter's diabetes supplies. So they left a message. And if you scroll down, it looks like they left a message about a sensor for my daughter. If I could turn the page. And if you could go up. So here again, like I said, you should have no doubts about the fact that I had my phone on me. Whatever anybody tries to argue, because again, I clearly had it. Went from the check-in. I say I had it all day. They may try to argue otherwise, but. So when we continue on again, there's that message. Then my ex-wife sends me a message at 1:26, and I don't immediately respond to it. And I don't feel the need to respond to every single text message immediately. I don't know, I'm personally that way. If I don't find a sense of urgency in it, I believe it can wait a bit. Sometimes I won't respond to, even if it's a person who's sending me a text message, I won't respond to the next day. It's just whatever mood I'm in. So I personally don't think that there's anything suspicious about my phone use here. Thank you, sir, very much. So I went to the gym, like I said, at about 12 and got checked in about 12:09. Did my workout, went home, picked up kids later, and, you know, I can't imagine the kind of person that would.
Objection.
Sustained.
So I personally can't imagine myself to be the kind of person.
Sustained.
I am not the kind of person who would stab someone.
The objection was sustained.
Okay. So,
Can we just go back through the cell phone data for a minute? He testified unequivocally that he logged in to Planet Fitness from his phone, which means he was with his phone wherever it was when he checked in to Planet Fitness, according to him. Both his witness and the state's expert witness both said his phone was at home all this time. How could he possibly have checked into Planet Fitness from his phone if he was at home the entire time? And if he was with his phone the entire day, as he's testifying, then why does the phone ping from his home this entire time? Now, text messages. 10:36, message from wife with a pic from daughter. I was out for a walk, so I didn't respond. The text message was immediately followed up by a phone call from his wife. Well, at that point, I was returning home from the walk, and so there was no point in me answering the phone because I was about to be at home anyway. And, so that's where my wife was. So I was going to see her. No point in talking to her on the phone. There are several calendar invites that he didn't do anything with. No explanation as to why. At about 12:53, there was stuff going on his phone, but he was at the gym. So he wasn't responding because he's working out. The gym, no, he's not done, MC. He's not done. We just have it on pause, just so we can go back through everything he said. He said he went to the gym at about 12. He checked in at about 12:09. He said he typically stays at the gym for about an hour. After he left the gym, he went home. He picked up his kids later. But at 12:53, he was at the gym. At some point, a vendor for his daughter's diabetes supplies called. And he said, I don't know why I wouldn't answer that. Maybe I was in the shower. He doesn't say when I got out the shower, I called them back because, again, it's a vendor for my daughter's diabetes supplies. He doesn't say that. His wife, who at this point has been at home, she was at home at 10 something. So at 1:26, his wife sends him another message. He says, I don't immediately respond. Well, he said he went to the gym at 12, checked in at 12:09. He typically stays for an hour. So at 1:26, he's no longer at the gym, according to his own testimony. But he says, I don't immediately respond. Then he says, I personally don't see anything suspicious about, my cell phone activity, how I use my cell phone. We all do. And at this point, the jury probably does. Because according to your phone records, you haven't used your phone since 8:43 a.m. And it's 2:40 and you haven't touched your phone at all. There's absolutely no evidence that you have touched your phone at all. But you're trying to explain away all this stuff that nobody even brought up. At this point, we were all kind of assuming that just about every one of these messages was junk. He's now giving us specifics. He's saying it was my wife. It was my daughter's diabetes supplier. It was my wife again. That's not junk messages. These are substantive calls and text messages that he has no way of explaining away. He is doing himself far more harm than good here. I really don't understand. I am at a total loss here. The court is going to be going into recess soon, but we've got a little bit of catching up to do here. While I try to get this reloaded, so we can finish out this AM session. Miss Carroll says, my parents' property butts up to ours, and I've been walking back from their house when my husband calls and I answer. But he was returning home, so he didn't think that it was necessary to answer when his wife called. Immediately after she text messaged him. So obviously she really wanted to talk to him, but he was just on a walk around his neighborhood. So there was really no reason for him to answer his wife's call at that particular time. So the reason that we're experiencing some difficulty now is because the Court TV has stopped for the day. So I've got to load the file when they post it, and it doesn't look like it's quite posted yet. So here we go.
So I
Morning
personally
session.
can't imagine myself to be the kind of person.
Sustained.
I am not the kind of person who would stab someone.
The objection was sustained.
Okay. So I've never beat anybody up. I've never killed anybody. I didn't kill Mr. Gurman. And that's my testimony.
Okay. Cross-examination.
I'm gonna need a break, just
Oh,
like
that's
organized.
Okay. All right, we're gonna take a recess. During this recess, you're marching out to the
Oh, we were at the very end of his testimony. So the narrative is over, people. The narrative is over. And it looks like the court actually is on a short break while the prosecution prepares to cross-examine this particular witness. Jeff says his goose is cooked if he got on the stand or not. And Miss Carroll agrees. But according to Mr. Tellis, he is not the type of person who would stab somebody. He did not kill Mr. Gehrman. He didn't do it. How did he deal with the evidence? He said, I didn't cut up any shoes or hat. I didn't hide shoes or a hat. I didn't have his address, so I could not have used his address to get his car information. DNA evidence has been planted before. I didn't look up his home on Google Maps, again, because I didn't have the address. With respect to his phone records, he was at home at 9:10 a.m. after his daughter text messaged him at 8:48 and he responded. He was still at home at 9:10. He said he remained home until he went to the gym at about noon. He logged into the gym on his cell phone. He had his cell phone with him the entire day, including while he was on a walk that morning, during which he got a text message from his wife that he didn't respond to. He got a call from his wife that he didn't answer. He had several calendar invites that he did not respond to. This is all in addition to the junk mail that he received. This is the actual substantive text messages, emails, and phone calls that he received. 12:53, he was at the gym, so he stopped responding to anything. Not that he was responding to anything prior to 12:53. A vendor for his daughter's diabetes supplies called. He didn't answer. He doesn't know why. Maybe he was in the shower. Who knows? Didn't call him back either. It wasn't until 2 something in the afternoon that he finally started using his phone according to the information that both his expert and the state's expert testified to. His wife sent him another message at 1:26 and he didn't respond. He said, because, I just don't respond to stuff immediately. I mean, that's just, kind of my thing. I don't find this suspicious at all. With respect to the cut, he cut himself cooking. To aid in the healing process, he put super glue on it. In order to get at the super glue, because it got kind of hard at the tip, he had to use some scissors to cut off the tip. While he was using the scissors to cut off the tip of the super glue, he got blood on the scissors. He returned the scissors to his garage, but he forgot to clean that blood off. And that's why the police officers found the bloody scissors in the garage. Not that they had tied those scissors to the crime at all, but Mr. Tellers had to explain those scissors away. The emails between Mr. Tejas and Roberto Lee Kennett, remember those emails, those other communications. Mr. Gehrman had done a FOIA request to try to get at those communications, and that FOIA request was going to be answered within about, I don't know, probably 24 hours of when Mr. Gehrman was killed. He wants the jury to have access to all of those communications so that they can read each one of them and determine if there was any motive for murder in any of those communications. The jury is going to get all of those emails and other communications through, I believe they said it was Teams chats. Who's taking odds as to whether or not the jury reads each one of those emails, considering that it wasn't necessarily the prosecution's position that the emails and the communications were the direct motive? It was more, he lost his job and he was being smeared in the newspaper, and it was clear that Mr. Gehrman was continuing his investigation and was going to continue to smear Mr. Tejas in the newspapers, that was the motive. So regardless of what was actually in the communications, it was the fact that Mr. Gehrman was still investigating him that provided the motive. Catherine, good to see you in here. Thanks for joining us. But that's how he dealt with that, or tried to deal with it anyway. He said it would have taken combat training to inflict the types of wounds on the decedent that were inflicted on him. And He just doesn't have that type of training. So that's how he dealt with that. Of course, he is a self-taught man, taught himself. He was a leasing agent and a property manager, and then somehow ended up as a maintenance man in property management. And he was self-taught with respect to, how to repair things. He even went so far as to teach himself how to fix air conditioners and took, the Freon tests and whatever other tests are required by Nevada law in order to fix air conditioners. And he did it all on his own, self-taught. But he certainly couldn't have taught himself how to apply a knife to a throat. That requires specific combat training. Underlying all of this is the fact that he is innocent. He has professed his innocence multiple times on the stand, and we should take his word for it. But essentially, dealing with all of the evidence in the way that he dealt with it, the jury has to believe that Compass Realty, Detective Jappy, pretty much every detective with the Metropolitan, the Las Vegas Metropolitan Police Department, have to have been involved in a conspiracy. Added to that conspiracy are other players as well. The crime scene analysts, the medical examiner, pretty much everybody who has been involved in this case at all has to be somehow involved in the conspiracy to have framed Mr. Tejas for this crime. Now, that conspiracy had to begin at least at the moment that someone decided to use a vehicle that looks just like Robert Tejas' vehicle in the commission of the crime. So it's not just framing Robert Tejas for the murder after the murder occurred that constitutes the conspiracy. The conspiracy involves the murder itself. All of these people had to have been party to a conspiracy to murder Jeff Gehrman and frame Robert Tejas for that murder. And the only potential motive that we have been given to this point is that Compass Realty was losing money in Clark County, Nevada, because they were being deprived of the ability to cheat in probate sales. We don't know what Detective Jappy's motive was to be involved in a conspiracy to commit murder and frame somebody for it. We don't know what all the other detectives' motive was to be involved in a conspiracy to murder someone and frame somebody for it. We don't know what the CSI team's motive was, what the medical examiner's motive was. We don't know why any of these people might have decided that they were going to put their lives and their livelihoods, their morals, their ethics on the line in order to be involved in a conspiracy to murder someone, to follow through with that conspiracy, and then frame somebody for the murder. Nobody's given us that motive. All we know is Compass Realty was losing money. And we don't even know that. We know Detective Jappy asked the district attorney to continue the investigation into Compass Realty and to prosecute them based on what he found during his investigation of Compass Realty. We also know that Detective Jappy did not ask the district attorney to prosecute Robert Tejas because he was unable to find enough evidence in his investigation of Mr. Tejas to indicate that he might somehow have been involved in nefarious dealings with respect to the public administrator's office. So with respect to that, there was no motive for Detective Jappy to just do everything he possibly could to harm Robert Tejas. And ostensibly, there's no connection between the detective who suggested that Compass Realty should be prosecuted, brought up on charges for things, that the people associated with Compass Realty are doing something wrong, and the prosecutor's office, the district attorney's office, needs to intervene. There is nothing that is indicating that perhaps Detective Jappy and Compass Realty are somehow tied at the hip and would collaborate with each other to commit murder and frame Robert Tejas for it. Absolutely nothing. But Mr. Tejas got on the stand and said it would be quite the coincidence that all of this with respect to Mr. Gehrman befalls me, and it benefits Compass such that they get off with no repercussions. It would be quite the coincidence. Surely, jury, you should not believe that this is a mere coincidence, but you should definitely believe that it is a mere coincidence that I happen not to respond to text messages immediately or answer phone calls from my wife or the vendor that supplies the diabetic supplies for my daughter. You should believe that that is just a coincidence and that it is merely coincidental that for the entire time that this crime was being committed, I did not touch my cell phone and it just sat in my house that entire time. But oh yeah, even though it sat in my house that entire time, I also used it to check in to Planet Fitness. Because I was at Planet Fitness. That's my alibi. I had to be there. So if I wasn't there, then that means I might have been committing murder. And I certainly wasn't doing that. I just told you that. Jury, you should definitely believe that it is mere coincidence that these detectives, not Detective Jappy because he wasn't in the house, but these other detectives found shoes that looked just like the assailant's shoes in my house and they were all cut up. That's way too coincidental to have actually happened for those shoes to actually be mine. It's mere coincidence that they found the cut up hat in my garage. I mean, that hat did not belong to me. Surely you've seen in other cases that police departments do plant DNA evidence. I don't know, guys. If I'm on the jury, this entire exercise in allowing the defendant to give a narrative in his own defense is disregarded. He has said absolutely nothing that would influence me in any way if I was on the jury. I don't see how anything he said could influence someone on the jury. The jury is there to follow the evidence. And again, if every jury that's ever impaneled believes a defendant when they say the police made up all the evidence, everything was planted, including the DNA, if that is enough to cast reasonable doubt in the face of a mountain of evidence, then we are wasting our time and our money on police departments, district attorneys' offices, prosecutors, and the criminal justice system as a whole. If all I have to do is come in and say, all of this evidence is made up, if that's enough to convince the jury, if that's enough to plant reasonable doubt, then all of this is for nothing. So if we believe in the criminal justice system at all, even one iota, then we have to have some discernible dots to connect if we are going to allege that it is a conspiracy that led a defendant to be in the position that the defendant is in. And he didn't give us those discernible dots to connect. I'm not saying it can't happen. I'm not saying that there are not times that police officers plant evidence. I'm certainly not saying that. I'm not even saying that every time they plant evidence, they get caught for it. I'm saying that we've been given absolutely no reason to believe that they planted evidence in this case. I don't know, guys. I don't know. Clearly, Mr. Raffensberger, I believe his name is, the criminal defense attorney, was none too thrilled at the idea of Robert Tejas taking the stand. He didn't want any parts of it. It looked like he was being forced to come to the bench whenever there was an objection because he didn't want to argue the other side of the objection. He didn't want any parts of this. He knows that Robert Tejas had an uphill battle in this case. And he likely knows that there was absolutely nothing he could do here to paint Robert Tejas in a good light because of the mountain of evidence that painted him in a bad light. So the young lady that I pointed out in the audience that was wearing the blue dress, she is, as I said, a reporter She works for 8 News Now, which is a Las Vegas television station. They interviewed Mr. Draskovich the day before he took the stand, so 2 days ago. And it was clear from that interview that it was Robert Tejas who wanted to take the stand. It wasn't his defense attorney that wanted him to take the stand. And there's a very good reason for that. The jury does not want to be there. All of you have seen, if you have not, even if you haven't experienced it yourself, that jurors, potential jurors, often do everything that they possibly can to get kicked off a jury panel because they don't want to sit through a trial. They don't want to deal with it. It's not, why would somebody want to take all of that time out of their schedule to deal with somebody else's problems? Yeah, it's our civic duty. Yeah, we are kind of required to do it. But that doesn't mean we really want to. Oftentimes, Miss Carol wants to go serve jury duty. Good for you, Miss Carol. You get on that jury. Miss Carol wants to serve jury duty, but a whole lot of people don't. And it's got to be stressful, right? Having someone's life in your hands. The decision you make determines how they spend the rest of their life. So I don't think Robert Draskovich wanted to waste the jury's time with a bunch of stuff that doesn't matter. But his client did. And there's nothing Robert Draskovich can do about it. So let's watch a little bit of the interview of Mr. Draskovich from yesterday.
Prosecutors have shown this was part of Tellis's downfall as Clark County public administrator, but again, they didn't ask the witness. Now, defense attorney Robert Draskovich says he discussed potential pitfalls with Tellis about getting on the stand, but Tellis is still choosing to take the stand. I talked with Draskovich briefly before he left court today. What do you want to say about him taking the stand?
He has wanted to tell his story since long before I was retained on this case. I remember seeing him on TV and various news outlets saying that he wanted to tell his story. Anticipate him telling that story tomorrow.
The evidence appeared to be overwhelming. How much is your work cut out for you?
It's been cut out since before the trial started. We've addressed the evidence the best we can. Obviously, facts, circumstances are things that we generally have to deal with in very serious cases, including this one. When you're called upon to give expert testimony,
Draskovich says at least
Facts and evidence. So this is the young lady in blue that was talking. That's the one woman that was interviewing him outside the courtroom. She's been in the courtroom every day. Draskovich said facts and evidence, bad facts, bad evidence is something that we have to deal with all the time. He knew that this was likely not going to go well. He's known that since he got on this case. He knew it when he saw newspaper articles and news footage and all the stuff that was coming out in the state of Nevada, in Las Vegas, for the past 2 years with respect to this crime. Because in Las Vegas, this is a high-profile crime. This is a reporter who was assassinated. A prominent reporter. One, again, who investigated Joe Pesci's character in Casino. So he's known since he got on this case, since Robert Tellis decided to get rid of his prior counsel, several of them, and was finally convinced not to defend himself in this action, which would have been a unmitigated disaster. He's known since he got on this case that this was going to be an uphill battle. And I believe he said, or the reporter said, that he has repeatedly told his client the potential pitfalls of taking the stand in this case. He knows it was a bad idea. He warned his client it was a bad idea, and he didn't want anything to do with it. And so we got everything in narrative form, and it was an unmitigated disaster. Movie Mood says planting evidence is mostly done by bad cops at traffic stops. I remember a case from years ago, Zach Wester, after self-incriminating body cam videos and other evidence. So that brings up an interesting point about this case. The defense made a big deal about the loss of that body camera footage on the day that Mr. Tejas was taken in, the day that he was detained, but before he was arrested. That missing body cam footage. Maybe, just maybe, missing body cam footage would have shown some nefarious activity on the part of the police. But here's the problem. They weren't at his house. So the body cam footage wouldn't have shown anybody planting evidence. They weren't there for the arrest of Mr. Tejas, so it wouldn't have shown something happening during the arrest. The missing body cam footage in this case wouldn't have shown any evidence of anything wrong. But we're back.
Yes, there's a question as to what doors perhaps were open in reference to communications between.
Let's see where this is going to go.
Tellis and Roberta. There's been a production made. We've had certain communications produced. We need to go through those. I think there's going to be a dispute as to what the scope, what's to be turned over, what's not, if there's been a privilege that's been previously asserted or not, if there's been any waiver. I think that's something that we're not going to get done until after lunch. We're going through
Okay,
them.
but can we start, and then that issue can,
I would prefer to know the, we can just lay it out pretty easily. Mr. Tellis got up here and had wanted all of the team's messages admitted into evidence. So that would be our request. There has been a production that we have that the defense
I love this
has
judge.
of team's messages. We provided those messages. Sounds like the defense's concern is maybe there's another production of team's messages because, I mean, the long and the short of it is some of the team's messages contains information that I think Mr. Tellis finds fairly damaging. And so he wanted them in. We agreed, fine, let's let them in. And now there's an issue of, well, I don't necessarily, I don't know that those are all of the messages. So what we're trying to nail down is the information. I mean, they have these have been produced. I can see in our files, these have been produced. I don't exactly know what he is looking at. I know the nature of the emails, the nature of the team's messages that are the source of consternation for Mr. Tellis has nothing to do with an attorney-client privilege. It has nothing to do with, something that would be privileged to the public administration's office. It just deals with something else. So.
what's the privilege?
Again, too, it could go into bad care. Well, we need to see what privilege was previously asserted or not. It's the state's argument, and I understand their argument. They're saying that Mr. Tellis, by his request, opened the door. As we addressed yesterday, Mr. Tellis is testifying in a narrative sense. We put the court on notice. The court had allowed that to occur.
Sure.
My concern is we would like to pull up on the jabs or otherwise what specific request he had made. There may have been a misunderstanding on the part of the state what it was that he was asking to have admitted. We want the break to go through that because it's the scope of what his request was. Obviously, it wasn't in response to a question or request that I had made. It was that which was made by Mr. Tejas. But again, I'd like to see that on the video, which we'll be able to address over the lunch break, because I think it's concerning a scope of the production.
Well, what do you think it was, Mr. Draskowitz? I mean, because it appeared to me as though, just a minute, it appeared to me as though he was requesting, the witness that came and testified and talked about that production that was about to happen, I don't know, in the first part of September. I mean, that appeared to be what he was asking the state to put on a disc and produce.
Yeah. So what I was requesting to be produced is actually what was produced to me
Okay.
in support of what was going to produce to Mr. Gurman. And so,
Right.
and so any and all, messages of any personal nature, in the review of the documents that I saw, anything personal, like, talked about perhaps going to the mall or whatever, that was already removed by the time I viewed it. So when Mr. Hammer is coming here with these messages, that was pre-trimmed. So I believe he's going to say that, look, this is why Mr. Tejas decided he was going to be angry, but that's not true, because the version that I saw had already trimmed out all these personal messages. So it's misleading the jury about what Roberta
What
testified
do you
to.
mean trimmed out? You
So
mean by the
basically,
county?
yeah, Clark County has a policy where they run it through various personnel, because their policy is to only produce business records,
Okay.
no matter what. They do not allow for the production in public records requests for messages of anything of a personal nature. And so, again, I believe it's in bad faith that Mr. Hamner is trying to show the original production and not what I personally saw. Because what I saw had nothing that referenced the mall or anything like that. And, and if Ms. Lee Kennett had any such concern, she would have said the same thing. She would have said, well, yeah, I had a concern with this, but clearly she saw the same messages I did. We saw no concern because personal messages had already been stripped out. And now we're at the point where Mr. Hammer's trying to mislead the jury about what I saw.
And obviously this predates this gentleman being charged. This predates. We're not talking about production due to course
It's the
of
Freedom of
discovery in a
Information
criminal
Act
case.
request.
And this obviously predated this case. So we're talking about back when Mr. Tellis was at the public administrator's office,
Right.
what he was given, what he saw, and I think that goes to the very point. It's referring to what his knowledge was back in that time, and that's why we want to address the scope of what it is the state intends to produce.
Mr. Hamlin?
Our position is, we have these text messages, it's not about taking a walk. Look, we'll call it out for what it is. I mean, it is, they are romantic messages between those two, okay? I mean, that's the reality of it. That's what's in the team's messages. There's, I have team's messages here that contain that. They may be right, maybe there is another version of this, but the team's message that we have, that we've produced to them, contain this information. Mr. Tellis got on the stand, and when he told this jury, he was like, oh, I looked at those team's messages, and I didn't have any issues with it. I'd like them all admitted. He did not put them together on a USB drive or anything, right? They did not come here and say, and here they are. They didn't produce them to us for us to review to see if there was any sort of discrepancy. I said, we have the team's messages, we can add them, and now they're reviewing, and that's fine, like if we want to get clarity on this, but clearly it changes the tenor of everything, right? And listen, if he looks at the jury and says, oh, I was totally fine with those messages, and let's say they missed them. What if they read them and they missed the couple of instances where they were telling each other how they felt about each other? You know what I mean? Like, then that's a misstep on his part. Now listen, if it wasn't produced, and there's some county law that's out there that doesn't allow that, but if we think about what the FOIA request, which we actually have here from Mr. Garman, which has been admitted, which was, we want all team's messages between Roberta and Mr. Tellis, and all of his articles when raising her has to do with the inappropriate affair. It seems to me that absent, some attorney-client, some applicable privilege, it is beyond me how that would somehow be pulled out.
And
Right,
again,
didn't the request ask for communication
All
between those two?
communications. He wanted personal text messages. He wanted Teams messages. He wanted emails. And he said from January of 2022 till this request is filled. And these messages appear in February and March and roughly around there. I don't know it all off the top of my head. I mean, I have excerpts of them. I have a paper version of excerpts of them as well, if the court would like to look at it. But I don't have any objection with trying to get to the bottom of, you know, did DA Civil really claw back, you know, the romantic messages? You know, I don't have an issue with doing that, but we need time, and I don't want my cross to start without this clarity.
and again, as to the scope, there was testimony, and I would submit that his testimony, his narrative testimony and that of Lee Kennett was similar in that in August of 2022, there wasn't an issue. Apparently both he had seen what was going to be turned over to Mr. Gehrman, and she did too, and there were no concerns. So my concern is what the state is attempting to present to the jury is outside of the scope of what my client's knowledge was at that point in time.
They both saw what was gonna be produced?
Yeah, I mean, the bottom line is this. This guy got on the stand and said, I want every Teams message admitted, but I haven't really compiled it. State, little help, here's the Teams messages that we have. And now they have a problem with them. And again, I reiterate, I am okay with taking the time to try to delve in to see.
Okay, but how much? I mean, 30
I mean-
minutes? We can break till 1 o'clock?
I mean, I don't know if it lasts that long. I mean, my thought would be, can we take a lunch break? Because if it
Right,
takes
that's what
long.
I'm saying, it's 12:30?
Yeah.
Just take 30 more minutes till 1 o'clock?
That's fine, yeah, you're right.
1:15?
Sure.
We can
Okay,
attempt to, yeah, we can.
1:15. All right, we'll see you
All right.
guys at 1:15 then. But what, we brought lunch in already, so we'll just let
Okay.
the jury eat now.
So you all understand the nature of the problem here. So Gehrman gets on the stand and says, give him all the Teams messages. And in the jury's mind, no messages have been called out. Nobody has gotten up there and said these certain messages have been called out. The romantic messages between Tejas and Roberta Lee Kennett have been called out. The fact that those messages exist then would be hidden from the jury because in their mind, Gehrman asked for all the messages. Lee Kennett testifies, yeah, but what we were going to give, nobody had any problems with. Tejas didn't have any problems with it either, right? But here's the issue. If in the jury's mind that those messages that they receive comprise the sum total of all of the messages between Tejas and Roberta Lee Kennett, and there are no messages in there that are romantic in nature, then they think such messages don't exist, but Tejas knows that they do. And now he knows, as of right before this crime occurred, he knows Mr. Gehrman is looking for them. And if he keeps looking, somebody in my office is likely going to produce them to him if they haven't already. And not only that, but if we end up in litigation over this, which he now is, all of these messages are going to come out because there is no privilege associated with the message. It just happens to be the policy of the communications department not to release personal messages between office staff members. So essentially, Robert Tejas is asking, Judge, will you please allow me to mislead the jury? The prosecution is saying, that's not the understanding the jury is going to be under. But, you know, if you want to go down this road, Judge, let's go down this road. But in the end, the prosecutor is going to be able to get up there and say, is this all of the messages between you and Roberta Lee Kennett? And at that point, the judge is going to know, the defense attorney is going to know, the prosecutor is going to know, and Robert Tejas is going to know that the answer to that question has to be no. this is not all of the messages between me and Roberta Lee Kennett. And then when the prosecution says, and had this investigation continued, or if these messages were, if the additional messages were asked for through a request for production in a lawsuit, would additional messages have come out? And what would those messages have shown? And he's going to have to answer those questions. So it doesn't really matter what they decide here, because in the end, the jury's going to find out these messages existed. At least that's my understanding of what's going on here. And now the judge is going to have to deal with all this. And the judge looks like she's calling BS with respect to what the defense attorney is saying. And the defense attorney is doing a very good job of trying to protect his client, even though his client is being himself right now. His client is being himself right now. I'll just leave it at that. She's calling BS on what the defense attorney is saying, but at the same time is trying to honor the spirit of Mr. Tellis's request. So we'll see how this pans out. We're going to pause here. I'm going to immediately throw up another invitation to the next Zoom, which will be beginning here in probably about 30 minutes or so, because they are on lunch break, but the jury's lunch break. This is all based on the jury's time, just so everyone knows. All courts run their court based on how to inconvenience the jury the least. So the jury has already started eating lunch. So we're going to have a short break in between these two lives, and then we'll pick up with the afternoon session here momentarily. Thank you, everybody, for joining me. I hope you join me for the afternoon portion of this. My name is Nathan Saunders, and this is The Legal Good.